We have seen that, according to the Supreme Court, race is a suspect class, and that laws that discriminate on the basis of race are analyzed using the strict scrutiny test. We have also seen that gender is a semi-suspect class, and that laws that discriminate on the basis of gender are analyzed using the intermediate scrutiny test. What about laws that discriminate against people on the basis of their sexual orientation or their gender identity? The court's first major statement on this issue came in the case of Romer v. Evans. In the 1990s, Colorado was a conservative state, but it had some liberal cities. Some of those cities passed ordinances that prohibited discrimination against gays and lesbians. But conservatives didn't like those ordinances, so they proposed a statewide constitutional amendment. Amendment 2 prohibited any governments in the state of Colorado from passing any laws protecting gays and lesbians from discrimination. In a 6-3 decision, the court ruled that Amendment 2 was unconstitutional. In his majority opinion, Justice Kennedy didn't declare gays and lesbians to be a suspect class. He said that wasn't necessary, because the law failed even the rational basis test. He wrote, "The amendment seems inexplicable by anything but animus toward the class it affects. It lacks a rational relationship to legitimate state interests. It is not within our constitutional tradition to enact laws of this sort. A law declaring that in general, it shall be more difficult for one group of citizens than for all others to seek aid from the government, is itself a denial of equal protection of the laws in the most literal sense." Justice Antonin Scalia wrote a dissenting opinion in which he argued that animosity toward gays was indeed a rational basis for the law. He said that Amendment 2 was a modest attempt by seemingly tolerant Coloradans to preserve traditional sexual mores against the efforts of a politically powerful minority to revise those mores through use of the laws. This court has no business imposing upon all Americans the resolution favored by the elite class from which the members of this institution are selected, pronouncing that animosity toward homosexuality is evil. I vigorously dissent. Of course, it is our moral heritage that one should not hate any human being or class of human beings. But I had thought that one could consider certain conduct reprehensible. Murder, for example, or polygamy, or cruelty to animals, and could exhibit even animus toward such conduct. Surely that is the only sort of animus at issue here, moral disapproval of homosexual conduct. Coloradans are entitled to be hostile to homosexual conduct. One fundamental disagreement between liberals and conservatives is whether civil rights laws that protect gays from discrimination constitute equal treatment, or whether they constitute preferential treatment. Justice Scalia argued that the only denial of equal treatment homosexuals have suffered is this: they may not obtain preferential treatment. Justice Kennedy responded, "We find nothing special in the protections Amendment 2 withholds. These are protections taken for granted by most people, either because they already have them or do not need them. These are protections against exclusion from an almost limitless number of transactions and endeavors that constitute ordinary civic life in a free society." So this ruling was a victory for gay rights, but the court didn't actually declare gays and lesbians to be a suspect class. On May 17, 2004, the Supreme Court of the state of Massachusetts shocked the nation by declaring that gays had a right to get married under the Massachusetts state constitution. This made it the first state to legalize gay marriage, but it would not be the last. The Supreme Courts of Hawaii and Iowa handed down similar rulings soon thereafter. At the time, strong majorities were opposed to the idea of gay marriage, and these rulings set off political battles across the nation. For example, opponents of gay marriage in Iowa succeeded in removing 2 of the state's Supreme Court justices who had voted in favor of it.
Iowa voters made history last election, holding activist Supreme Court judges accountable for ignoring our will and imposing gay marriage. Now we must hold David Wiggins accountable for redefining marriage and legislating from the bench.
And opponents succeeded in passing ballot initiatives banning gay marriage in several states. For example, in 2008, California voters approved Proposition 8, a state constitutional amendment limiting marriage to one man and one woman. At the federal level, Congress passed the Defense of Marriage Act by large majorities. This law specifically excluded same-sex couples from receiving the same federal legal benefits as straight couples. But then things changed. In less than 5 years, public opinion on the issue of gay marriage changed dramatically. Significant majorities in many states began to support gay marriage rather than oppose it. By 2015, 36 states had legalized gay marriage. And the courts began to reflect this change. In 2013, the Supreme Court issued a ruling that had the effect of striking down California's Proposition 8, which legalized gay marriage in America's largest state. While this was a major victory, it was also a limited one, because the decision was made on a technicality. It did not address the Equal Protection Clause, and it only applied to California. The other states would have to wait. But they wouldn't have to wait for long. On June 26, 2015, the Supreme Court handed down a pair of major rulings. One struck down the Defense of Marriage Act, and the other struck down laws limiting gay marriage. Writing in the case of Obergefell v. Hodges, Justice Kennedy said, "No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were." As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. Gay marriage was established as a constitutional principle in 2015. However, the court still didn't declare homosexuality to be a suspect class. And like so many other areas of law, it may not last. The court legalized gay marriage in a 5-4 decision. But after years of being closely divided between liberals and conservatives, the conservatives now have a clear majority. Justice Anthony Kennedy and Justice Ruth Bader Ginsburg are gone, both having been replaced by extremely conservative justices. Just as they overturned the constitutional right to abortion in June 2022, some have expressed the desire to overturn the gay marriage decision. Only time will tell. But even if the court's conservatives do not allow states to restrict gay marriage, they have already demonstrated that they are willing to allow discrimination against gays under the guise of religious freedom. That topic is explored in a later video.